Hello there and welcome to Court This Week. I'm Dina Osha. In the special editions, we bring to you top stories of the legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring us selections of major legal proceedings which made headlines this week. In this next half an hour, we will inform and update you all the important proceedings from the week. So let's start Courts This Week. Taking in consideration the fact that the migrant workers are not being provided proper jobs amidst the lockdown period, the Delhi High Court has ordered the government take steps for establishing a mechanism for registrations of the migrant workers. It has asked the central government to file an affidavit to inform the type of the online portal that is required to register migrant workers across the country. Delhi High Court has noted that there is a dire need for creating a mechanism for registrations of the migrant workers in Delhi. The single bench of Justice Pratibha M. Singh further directed the central government to submit a detailed affidavit highlighting the kind of portal it is proposing to create for the registrations of migrant workers in Delhi. The order has come in a writ petition filed by Shashank S. Mangal, seeking registration of migrant workers in Delhi. In the last hearing, the court has directed both the centre as well as the Delhi government to submit detailed status reports indicating the data related to migrant workers and the 3 procedures laid down for their registration. In today's hearing, the Delhi government informed the court that not a single worker is registered under the Interstate Migrant Workmen Regulations of Employment and Conditions of Service Act 1979. The government further informed that under the Building and Other Construction Workers Regulations of the Employment and Conditions of the Service Act of 1996, there are various schemes which are available for construction workers. It was also submitted by the Delhi government that during the lockdown period, 39,600 registered construction workers have been dispersed financial assistance. The court directed the central government to file a detailed affidavit highlighting the kind of portal which is sought to be created for the registrations of migrant labor across the country. Such a portal ought to have on board all the state governments so that the ingress and egress of the migrant labor is duly recorded and reported. The court will next take up the matter on July 22nd. Bureau Report. The Supreme Court has rejected the interim bail of Mahinder Singh Yadav, co-accused in the 1984 Anti-Sikh Riots. A bench of Justices Indira Banerjee and B.R. Gavai stated that no specific suggestions are put forth in the plea which prayed for interim bail for Yadav on account of being COVID-19 positive, and that everything possible was in fact being done in the furtherance of the treatment of Yadav. Court further noted that no other specific suggestions was forthcoming from the family which they wished to take. The plea contended that the petitioners had moved the present applications for interim bail as the petitioners have been tested corona positive on June 26 and his health is continuously deteriorating. Further, plea states the grounds for interim bail as that of the fact that Yadav, more than 70 years old and suffers from various ailments including inability to walk properly, acute diabetes and kidney issues. In May 2013, Congress leader Sajjan Kumar was awarded life imprisonment for nearly 29 years after 5 members of a family were killed in the Delhi cantonment area during the 1984 Anti-Sikh Riots. Ex-councillor Mahinder Yadav and ex-MLA Krishan Kokhar were found guilty of not only rioting and were awarded 3 years imprisonment. A petition has been filed in Supreme Court by a group of parents from various states seeking relief for paying school fees in private, aided, unaided schools for a month of April, May and June this year due to COVID-19 pandemic and lockdown. The petition seeks that the centre and the state government direct private schools not to charge any fees from students enrolled with those schools for a period of 3 months from April to June or till physical classes starts from lifting of the lockdown. Various prayers have been made for fee waivers relief in petitions. The petitioners prayed for directions so that schools only charge fees proportionate to the conduct of the online classes and further that only tuition fees be collected. No other component of the fees may be charged from the enrolled students, the plea prays. The waiver is sought until regular physical classes in school resume after the COVID-19 lockdown and restrictions on the functioning of schools are lifted, it is said. Further, a complete waiver of the fees is sought for students whose parents are currently not engaged in any vocations or who have faced a reduction in salary or who are not earning any income due to the COVID-19 pandemic and lockdown during the months between March and July. It is stated that the petitioners were constrained to approach the Supreme Court seeking protections of the fundamental rights of life and education guaranteed under the Constitution of India. A plea in the Supreme Court have been filed seeking directions for issuance of the guidelines vis-a-vis disposal of the clemency, mercy, writ petitions and resultant executions of the death sentence in a time-bound manner. Advocate Dr. Subhash Vijayarant has filed the petitions and highlights the irregularities in deciding the writ petitions across the high courts while particularly focusing on the case of the two-child murderer's sister, Renuka and Seema, convicted of murdering 5 children in a depraved manner. Petitioners argue that while the convicts in Delhi gang rape cum murder case were dealt with expeditiously because of the victims' parents' garnered support and resources to reach out to the judicial system, victims in the child murderers case were slum dwellers and lacked resources and support due to the death sentence of the convicts, though confirmed is pending since 2014. The petitioner states that the Constitution mandates the state to provide equal treatment and arbitrary selections and selectively executing some specific death row convicts while not bothering to execute other for decades is unethical and Article 14. Further to this, the petitions prayed for directions to the union and state to take necessary step in a time-bound manner to execute the sentence of death for those death row convicts who have exhausted their legal remedies, as well as issue notice to those death row convicts who have not exhausted their legal remedies, directing them to exhaust the same in a time-bound manner. The Punjab and Haryana High Court has denied the bail plea of a Class 12 student, a minor and the prime accused in 2017 Ryan School murder case. The single bench of Justice Arvind Singh Sangwan observed that the benefits of bail to a juvenile under Section 12 of the Juvenile Justice Care and Protections of Children Act 2015 could not be given the accused, as the Supreme Court has directed to treat him as an adult for the purposes of trial. The petitioners, who was a student of Class 11, have been charged with the killing of a 7-year-old inside school washroom in 2017. The Punjab and Haryana High Court has dismissed the bail plea filed by the school students accused in 2017 Gurugram private school murder case. The petitioner, who was a student of Class 11, have been charged with the murder of a 7-year-old child inside the school washroom. The Principal Magistrate Juvenile Justice Board Gurugram had earlier declined the grant of bail to the accused. Thereafter, the Appellate Court Additional Session Judge Gurugram also dismissed the appeal to move challenging the board's decision. The High Court has now dismissed the revision plea challenging these orders. The revision plea was moved on the ground that these orders denying bail were passed while touching upon the merits of the case. Justice Arvind Singh Sangwan passed the order while noting that the accused school students had to be treated as an adult in line with the Supreme Court orders passed on the issue. The Supreme Court had in its order passed in February 2019 and in April this year stated that the accused was to be treated as an adult for the purpose of deciding on bail. The High Court therefore stated that there was little scope for it to ascertain whether the bail could be granted under Section 12, grant of bail to a juvenile accused of the Juvenile Justice Act. Though it is well-settled principles of law that an application for the bail filed by a person who is above 16 years of age and is alleged to have committed a heinous crime pending preliminary assessment by the Juvenile Justice Board can be allowed. However, this court is not inclined to grant any relief to the petitioners in view of the order dated 28/2/2019 passed by the Honorable Supreme Court, directing that for deciding the bail petitions, the petitioners be treated as an adult. Therefore, there is little scope for this court to find out whether the petitioners can be granted the relief under Section 12 of the Act. The High Court, in dismissing the plea of the accused for bail, relied upon detailed orders that they have been passed by the Supreme Court and the Juvenile Justice Board that is overseeing the investigation in the case. The court noted the prosecution has cited certain witnesses who are minors, including the sister of the deceased, and therefore possibility of tampering the evidence cannot be ruled out at this stage in view of the totality of the circumstances and the affidavit filed by the CBI. In this backdrop, the court concluded that there was no ground to grant the concessions of bail to the accused and dismissed the revision plea. Bureau Report. The Supreme Court heard a plea on the deportations of the foreign Tabligis who had been part in the Nizamuddin Tablighi Jamaat Markaz. During the hearing, Center told the court that passport of 3,460 foreign Tabligis have been impounded. The center had also held that the right to return home is not an enforceable right. However, the court said that the blacklisted Tabligis can appeal to relevant authorities for their return back home.
The issue of deportation of foreign Tablighi nationals was heard in the Supreme Court. The bench of Justice A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna was hearing a plea filed by 34 foreign nationals challenging the decision of the Ministry of Home Affairs to blacklist over 3,000 of them from travelling to India for a period of 10 years. Solicitor General Tushar Mehta informed the Supreme Court that the centre had passed individual order to cancel the visas of over 3,460 foreign nationals who had taken part in Nizamuddin Tablighi Jamaat Markaz. The Supreme Court ordered that all the petitioners will be permitted to make representations before concerned authorities. It noted that since the centre had passed individual orders, the petitioners may challenge the same before concerned high courts. However, objecting to this, Solicitor General Tushar Mehta submitted that the blacklisting of an individual was a sovereign plenary function and that most of these individuals face criminal charges. He also submitted that right of return not an enforceable right. In response, Justice Khanwilkar stated that the centre can make these submissions before the competent authority. Senior advocate Chandarudai Singh, appearing for the petitioners, stated that the main issue here was of right to return. He also submitted that none of the orders passed had mentioned anything about blacklisting the foreign nationals. Senior advocate Dr. Menika Guruswamy submitted that the order passed by the centre against these foreign nationals were never sent to the petitioners. Thus, the court ordered that all such orders to be sent to the counsel for the petitioners via email. The case has now been adjourned to 10th of July, by which the date the petitioners are required to file a rejoinder to the affidavit submitted by the centre and also make representations before the competent authorities as regard deportation. On 29 June, the court had observed that there was only a press release stating how these foreigners were blacklisted and that the centre owned the explanation on whether there are official orders from the competent authority cancelling their visas. Bureau Report.
The Delhi High Court has issued notice in a plea seeking establishment of a system for re-registrations of all documents in order to dispense with the physical presence of all the parties. The division bench of Chief Justice D.N. Patel and Justice Pratik Jalant issued notices to the centre, the Delhi government, the Lieutenant Governor of Delhi and the Director of Controller of Accounts, Delhi Secretariat. The petition seeks a direction to be issued to the respondent to formulate policies and bring in the e-registrations of the documents documents which shall avoid the unnecessary rush in the sub-registrar's office and ensure the ease of registrations of the documents, the effective manner of the registration, and also avoid any red tapism or any manner of corruption which may have been existing at the sub-registrar's office. It is the case of the petitioners that the COVID-19 and the resultant lockdown had seriously affected the process of registration of documents concerning property, transfer of interests, lease, deeds, among others, which have seriously affected the rights of duties of the citizens. For instance, the petitioner submits the system of electronically calculating the stamp duty before submitting the documents to the sub-registrar can also be made public so that people could be saved from the last-minute hassles. Corruptions would also be checked and the instances of the wrong calculation of the stamp duty would minimize. The submission of the secret documents, the petitioner argued, can still be continued to be done through physical presence. The petitioners have further submitted that the sub-registrar's office can also become a single window transaction issue where the documents can be collected and deposited. Kerala High Court has directed the state government to ensure supply of ration cards, free medicines to the transgender community and not to deny any basic human rights to them.
On a public interest litigation filed by a transgender person, the Kerala High Court directed the state of Kerala to ensure the free supply of medicine in consonance with the policy of the state government whenever any member of the transgender community is approaching the concerned statutory authority with the medical prescription of a doctor. The petitioner contended for the benefit of law laid in the Apex Court decision in National Legal Service Authority versus Union of Indian and others, and presented before the court that the transgender community in Kerala, especially in the lockdown situations, are facing severe crisis in terms of access to essential food supply, medicines and allied treatments. Equally, they are facing threat of torture from the part of police authorities. The state of Kerala, through its affidavit, had contended that state of Kerala never followed a different treatment towards its people, especially in the time of these grave crises. They have made earnest efforts to protect the rights and interests of the transgender community. The state of Kerala submitted that the Kerala state is the first state in the country to implement such a policy for the holistic empowerment of the transgender community. The state had further stated some of the welfare measures they administered for the benefit of the transgender communities as follows. Authorities like Transgender Justice Board in the state level and a Transgender Justice Committee at the district level. Various schemes for the overall upliftment and protections of persons belong to transgender community in terms of self-employment, marriage assistance, financial aid for self-employment and sex rearrangement surgery, etc. A helpline facility and scholarship for the person belong to transgender community, etc. Treatment facilities including hormone therapy. Short stay home for the people belonging to the transgender community under the aegis of the Social Justice Department in 4th District, Thiruvananthapuram, Kottayam, Ernakulam and Kozhikode, etc. The court had observed that the identification of the transgender community is an issue involving privacy and it is the duty of the concerned authority to provide the documents once a person in need approaches for the issuance of the same. The court had equally identified the role of the members of the community or NGOs and others who are working with the transgender community to identify the issues faced by the transgender community and to direct the same to the authorities concerned. Bureau Report.
The Gujarat High Court has expressed concern that young boys who themselves are not mature in many a time without realizing the consequences of their act or many a times actuated by the frenzy of youth eventually label themselves as offenders in the matters of the POCSO. The bench of Justice Sonia Gokhani and Justice N.V. Anjaria was dealing with a habeas corpus petition by the father of a minor girl who had eloped with a boy who had himself a minor. Noticing that the respondent number 5 is himself a minor is yet to be found, the bench lamented, "We are also at pain to learn the thought he himself is a minor. He has chosen to take away the corpus, which is a minor, landing him in the net of the law, particularly of the Protections of the Children from Sexual Offences Act." While the court appreciated that this act is brought on the statute book with the laudable objective with a view to protect the girl child in the society. With more and more offences affecting the girl children, it expressed that right kind of understanding need to be given in the form of legal awareness amongst the children and the college students so that the society can simultaneously protect very young minor boys who, due to their lack of understanding of law, turn into offenders in serious matters. Accordingly, the bench directed the concerned Superintendent of Police to take up this issue with the Anti-Human Trafficking Cell and District Legal Services Authority for creating awareness amongst the youngsters. The Bombay High Court has disposed of a batch of the PILs raising concern regarding the lack of the facilities for proper treatment of the prisoners lodged in various correctional homes during the current pandemic of the COVID-19, after concluding that most of the suggestions proposed by the petitioners have been accepted by the state. The division bench, comprising Chief Justice Dipankar Datta and Justice M.S. Karnik, was informed by the Advocate General of Maharashtra, A.A. Kumbakorni, that the state has accepted the suggestions to conduct random testing of inmates across the jail circles or barracks. Thus, the court directed the prisoner authority to forthwith implement the measures for random testing. Several important suggestions were put forward by Senior Advocate Mahir Desai, who appeared on behalf of the petitioners, along with Advocate Isha Khandelwal. Some of the significant suggestions that have been accepted by the states are: the state deployed in the correctional homes will be tested in the same manner as the inmates as per SOP. As far as possible, the staff deployed in the correctional homes, temporary prisons, shall be posted in the present place of posting and they will not be rotated. Court directed the state to fully comply with the directions issued under the interim order passed in the matter and noted that the suggestions made by the petitioners were accepted by the state and their compliance was ensured by the Advocate General on behalf of the state. Court disposed of the PILs and dismissed one PIL filed by advocates Devmani Shukla and Nikita Abhyankar. Well, that's all in court this week. Thank you so much for tuning in and stay safe.